A mistake to avoid in high asset divorce cases is to hide assets. In a divorce case, there's full financial disclosure. All of your assets have to be divided up. Even if you have an account with somebody else and it's not your money, you need to disclose those assets. If you don't disclose assets and they get found out, your credibility is shot. The judge isn't going to believe a word you have to say, and there could be a negative inference drawn against you in how the assets are divided up. There must be full, complete transparency in a divorce, and you should never, ever hide an asset. When going through a high asset divorce, I always recommend my clients speak with their financial advisor and/or an accountant. Your financial advisor and/or your accountant is an indispensable piece in determining what assets you have and how they should be divided up. And the lawyer should work diligently with them to determine the best, most cost-effective way with the least tax consequences and how the asset gets divided up. When going through a high net worth divorce, it's always important to look at the tax consequences of dividing an asset. While as an attorney, we're not permitted to give tax advice, we can surely tell you to meet with your accountant and your financial advisor and to allow us to speak with them so we can minimize any tax impact in the future property division. In a high asset divorce, you never want to act on emotion. Your head is clouded. You're going through a very stressful time. You should never act on emotion. You need to be smart. You need to be systematic. You need to be pragmatic and work with your attorney, your financial advisors, and your accountants to minimize any negative impact that your divorce will have on your assets. If you have any questions regarding a high asset divorce, please call the law office of Jerome Sheriff and schedule a free consultation.